Hello, my name is Deanna Reed, and this is my review of Priceline.com's website terms and conditions for assignment number 4 in digital marketing and the law. Let's begin by viewing Priceline.com's current terms and conditions as of July 22, 2023. Most site terms and conditions can be found by accessing a link in the website's footer. This is a beneficial placement, as placing a link in a familiar location makes it easier for a user to locate when needed. That is where we can find Priceline.com's as well. Here, under About Priceline, let's click on the terms and conditions and see what they are. Now that we have arrived, let's review what terms and conditions are. A terms and conditions agreement is a contract between a service provider and its users. In this case, the terms and conditions are between Priceline.com and users of its website. The terms and conditions should explain what users can expect Priceline.com to provide and what Priceline.com expects from users in return. It is the legal contract that allows Priceline.com to manage customer expectations, set rules for service use, and prevent litigation when possible. However, just because Priceline.com writes up a set of terms and conditions, it doesn't mean that it is legally enforceable. Let's review what it takes to make the agreement enforceable under contract law. What makes a terms and conditions agreement legal and enforceable? Well, number one, it must be lawful. The terms and conditions are not requiring anyone to break any state or federal laws. Number two, it must be fair. There cannot be unreasonable or unfair demands on either party. Number three, it must be clear. Anyone viewing this agreement should be able to understand the contract and what they are agreeing to. Finally, number four, it must be agreed to. Both parties must consent to the contract before it's enforceable. In this case, it would be between Priceline and the users of its services. Are Priceline's terms and conditions legal? Let's look. Right away, the first thing I notice is that the terms and conditions are available in several languages. This allows for clarity so that users can read the terms and conditions in their language for better comprehension. Currently, English, Dutch, German, French, Spanish, Italian, Portuguese, and Japanese languages are available. Does Priceline.com provide services to users in countries that have a different dominant language, such as Russia? If so, Priceline.com should include the terms and conditions in those languages as well. Every terms and conditions agreement should include the following: a brief introduction, the effective date, jurisdiction governing law, link to the privacy policy, contact information, limitation of liability and disclaimer of warranties if applicable, rules of conduct, user restrictions, and third-party terms and conditions. While these are not required, they are beneficial to creating a clear, fair, and enforceable agreement. Below the language options, we see Priceline's introduction, which includes a link to the privacy policy. The introduction also includes a browser wrap clause stating that using the website constitutes agreement with the terms and conditions. Browser wrap clauses are difficult to enforce as they do not provide physical proof of mutual agreement and are unfair in that users would need to read the terms and conditions in order to know they are agreeing to them by using the site. If this clause is the only method used by Priceline.com to obtain agreement from users, then it would most likely not be legal or enforceable. In fact, Ironclad.com's ClickWrap litigation trends report shows that browse wraps had only 14% enforceability in recent years. However, if Priceline.com utilized ClickWrap to obtain users' agreement, it would be more enforceable. ClickWrap requires users to provide affirmative consent to the agreement by clicking a button or checking a box. This informs users of the existence of a contract and provides affirmative evidence of their agreement to the terms. There are notable case law examples to refer to. Spect versus Netscape is considered the original ClickWrap case. Netscape had a hyperlink to an agreement at the bottom of their webpage where users downloaded software, but this was not considered proper notice to users of Netscape's terms. Skoros versus TransUnion Corp was a little different. TransUnion had their terms in a scroll wrap on the screen and required users to check the agreement box before creating an account. However, the notice surrounding the checkbox, "I accept and continue," was not clear enough to inform users they were accepting a contract, and therefore the terms were unenforceable. In Berman versus Freedom Financial, the court found that including the term, "I understand and agree to the terms and conditions," which includes mandatory arbitration and privacy policy, was insufficient enough to call users' attention to the existence of the terms and conditions, or that clicking on the Continue button indicated agreement to the terms. Does Priceline have an enforceable click-wrap agreement? I went through the process of booking a hotel room to get to the checkout page. Towards the bottom of checkout, I discovered a hyperlink to the terms and conditions, but no agreement checkbox. It states that by selecting complete booking, the user agrees to the terms and conditions. However, that's just another browse wrap statement. Therefore, based on existing case law and the requirements for an enforceable agreement, I would determine the agreement as not legal or enforceable in its current state. To make it enforceable, Priceline.com can include a mandatory checkbox within the important information section that states the user has read and agrees to be bound by the terms and conditions, etc. This will provide Priceline.com with a digital record of the user's agreement and serve as proof of mutual agreement and proper notice. The next section is the arbitration and dispute resolution. This clause informs users of the steps necessary to notify Priceline.com of a dispute. Priceline.com establishes that Priceline has the first opportunity to correct any disputes, with notification being sent to customer support up to 2 years from the date the claim arose. After 60 days, if customer support is unable to resolve the claim, the users can seek relief through arbitration or small claims court within the restrictions outlined in the mandatory arbitration clause. This clause also establishes the jurisdiction and governing law, in this case, the state of Connecticut in the United States of America. The mandatory arbitration clause is common in most online service provider websites, and sometimes referred to as the arbitration and class action waiver. Arbitration is when the dispute is decided by an arbitrator, not a court. The decision is usually final with no opportunity to appeal. The class action waiver establishes that a user will not seek or join a class action lawsuit against Priceline.com. The mandatory arbitration clause for Priceline provides users with the ability to sue Priceline.com in small claims court in lieu of arbitration. The clause will not be enforced by a court if they determine the terms and conditions are unenforceable. Oberstein v. Live Nation Entertainment Incorporated is a notable case law example. The case questioned whether the arbitration and class action waiver clauses on Ticketmaster and Live Nation websites prevented plaintiffs from bringing a class action lawsuit. The plaintiffs claimed that the terms and conditions were invalid, as they did not list Ticketmaster and Live Nation by their full legal names, and the arbitration clause was unenforceable because plaintiffs were not required to complete a clip-wrap agreement. The Ticketmaster and Live Nation user interface required clicking on a separate link that opened a new browser tab containing the terms and conditions. The court decided that the terms and conditions were enforceable, as the law does not require that corporate parties contract using their full legal names, and the common trade names were an acceptable way to properly identify the entities. Next, the court determined that the arbitration and class action waiver clauses were enforceable, as the website, despite not utilizing click-wrap, presented users with a confirmation button directly below text that informed users that by clicking on Submit, they were accepting the terms of use. This occurred at 3 separate points on the website: creating an account, signing into the account, and completing a purchase. This means that arbitration and class action waivers can be enforceable as long as the terms and conditions are enforceable, parties to the agreement are adequately identified, and arbitration clauses are sufficiently noticeable to users. Therefore, in its current form, due to there being no click-wrap agreement on the terms and conditions, it is likely that a court would determine Priceline.com's terms and conditions unenforceable, resulting in the mandatory arbitration clause becoming void. This would allow for a class action lawsuit by users. If a court were to determine the terms and conditions are legal, then a user can sue Priceline.com only through small claims court with a maximum award of $5,000 as per Connecticut state law. The next section is related to credit card chargebacks. A credit card chargeback occurs when a customer contacts their bank directly to report an incorrect or disputed charge. The bank then charges the disputed amount to the service provider, in this case Priceline. Chargebacks incur fees and on average costs more than double the amount of the disputed transaction. Online retailers and service providers sometimes include a no chargebacks clause in their terms and conditions to avoid costly chargebacks. However, it is difficult to enforce a no chargebacks clause as the customer's bank has not been made aware of the agreement and they're likely not to ask if there was one. Additionally, consumers in the U.S. have the legal right to ask for a chargeback when they are defrauded. An enforceable terms and conditions agreement cannot supersede state and federal laws and regulations. Reviewing Priceline.com's credit card chargebacks clause, Priceline does not deny the user the ability to charge back, but instead encourages the user to contact Priceline first to dispute charges. It also explains the chargebacks that Priceline.com will dispute. Disclaimer of warranties. This clause is not a requirement, but it is helpful to have in a terms and conditions agreement as it can protect Priceline.com from liability if a user has a problem using the website. Priceline.com uses an as-is basis for their disclaimer, stating that all content on the site is provided on an as-is basis. This means that the user accepts and will not take action against Priceline.com for any issues they may encounter while using the website. This will protect Priceline.com in most cases. However, what happens if the Priceline.com website experiences an issue and is unavailable when someone is trying to access or cancel travel plans and it results in legal action? To further protect Priceline.com, the term as available should be added to the disclaimer of warranties, stating that all content on the site is provided on an as-is and as available basis. This provides an additional layer of protection from liability. General limitation of liability. A limitation of liability clause in terms and conditions usually serves two purposes. The first, to limit exposure to only direct damages. The second, to place a maximum financial limit on liability. Indemnification. A limitation of liability clause protects Priceline.com against excessive legal action from users. In contrast, an indemnification clause protects Priceline.com from the costs and fees resulting from user actions, including breaching the terms and conditions, violating any laws or rights of a third party, and using the site in violation to the agreement. It acts as an insurance, as by agreeing to the indemnity clause, the user is agreeing to be monetarily responsible to Priceline.com for anything that may go wrong due to the user's actions. A notable case law example is Hot Rods LLC versus Northrop Grumman Systems Corporation. In this case, Northrop sold property to Dan Weldon and his wife, who then assigned their rights to Hot Rods LLC, which they owned. The purchase agreement between Northrop and the Weldons included a mention of indemnity, stating, "Seller hereby agrees to indemnify, defend by legal counsel selected and retained by seller, harmless from and against any claims." After finding an underground storage tank on the property, Hot Rods LLC contacted Northrop for remediation. During remediation, Hot Rods LLC incurred loss of revenue due to tenants delaying the lease, several-day evacuation due to damage to the building, odors, and blocked access. Hot Rods filed a complaint against Northrop. However, Northrop argued that the indemnity clause was between the Weldons and Northrop and did not include third-party claims. Therefore, they were not required to cover any loss incurred by Hot Rods. The court evaluated the wording of the indemnity clause and determined that the statement against any claims was very broad and therefore covered third parties. The case emphasizes the need for broad and express language in indemnity clauses and to specifically address both direct and third-party claims in the provision. Priceline.com's indemnity clause is written clearly and addresses both direct and third-party claims and is therefore likely enforceable. Copyright and trademark notices. A copyright clause is used in the terms and conditions to establish what content within a website is claimed as its intellectual property. Priceline.com's clause lists content including logos, written content, photographs, videos, graphics, and more as intellectual property owned by Priceline.com, corporate affiliates, or travel service providers. The clause is written in easy-to-understand terms and is in accordance with public policy. Therefore, it would most likely be enforceable. Claims of copyright infringement. The copyright and trademark notices informed users of Priceline.com's intellectual property, and now the copyright infringement clause addresses any concerns of Priceline.com using someone else's intellectual property without authorization. It provides users with the steps needed to report an infringement on copyrighted work and is following the Digital Millennium Copyright Act. It is fair, easy to comprehend, and within state and federal laws and regulations. Therefore, it is reasonable to expect that this clause could be enforceable. Now that we have reviewed the terms and conditions, let's return to the initial question. Is it legal? Would a court enforce them? The individual clauses within the terms and conditions appear to adhere to best practices, are lawful, fair, and clear to understand. However, an agreement is the final requirement for them to be enforceable. As stated previously, Priceline.com currently uses a browse wrap statement rather than a click wrap agreement, which, as I have presented, is a cause for the court to determine the terms and conditions are not legally binding and enforceable. I have presented several recommendations for Priceline.com to improve its terms and conditions, to make it legal, enforceable, and reduce liability. However, it is recommended that Priceline.com additionally meet with a legal team specializing in contract law to review and suggest any additional changes.